Well, what the Isnaris did in the current law is it says that if you are in Isnari, an area of special natural interest, then the department can't consider mitigation. Period. That's what was in the current law. So in this law, what is proposed, or this proposal says, we're going to mitigate everything. If you get a permission to fill it into a high quality wetland, something that would have been Isnari, you still got to do mitigation. So the purpose of Isnaris was to pick up mitigation. The philosophy here is we're going to mitigate regardless of where we are. So that doesn't have any meaning anymore. So we're still going to mitigate for everything.
Are you going to be comfortable that mitigation is going to, you know, I've worked on mitigation projects, I've done research with them, and quite frankly, mitigation projects, while helpful, don't often replicate the same standards and qualities that the intact natural wetland does.
We're not changing, I'm sorry, we're not proposing to change the standards within this piece of proposal, but we are saying that after the decision is made, you still have to mitigate. So it's that mitigation is a tacked on part of the decision-making process. It's not part of the decision-making process.
I share Representative Malevsky's concern about the change of the language of avoid and minimize. I'm curious, I've read bills close enough to know that those things matter, and in that particular line, I still have to wonder if that's not important, that language be maintained if we're serious. I happen to have lived in a house that was built in the wetland. It was no fun. And it's no fun for the people that end up getting stuck with wet basements and things. So, and there's other elements that we have to consider.
I want to direct your attention to page 28 again, looking at lines 13 through 19. The three standards that we look at are it has to avoid, it has to minimize, and it can't have a significant adverse impact. Those three standards are maintained in this proposal.
Thank you for now.
Representative Clark.
Thank you, Mr. Chairman. And, thanks, Representative Mursaw, for, what I will say is that I appreciate that you are striving for balance here, and you've obviously done a great deal of work to incorporate some different ideas in the bill. And there are folks here who I'm sure will argue that we have a pretty good balance right now, but there's definitely improvements in this bill that I think most people would agree, move us forward. I would say for the record that for anyone watching years from now, it might be helpful if you refer to the bill as 463 and not 465, so nobody's confused. It is 463 we're hearing today, isn't it?
Yes, it is.
Okay, just checking on that. If I could ask a...
Follow your lead.
Well, I guess, as I went through it, you get these bill numbers at the last minute, and I look at it as a wetland bill. So, we're hearing a wetland bill today.
Thank you.
Regardless of what the number is.
We're all on that page. If I could, Mr. Johnson, a couple of questions. So, on page 27, line 20, there's the language in there that says that if the proposed project will result in a demonstrable economic benefit, some different things have to happen, and I gather that means that if it results in a demonstrable economic benefit, you have to limit your review to practical alternatives located at the site of the discharge or adjacent to the site. Can you describe what the implication of that change means? Can you describe what you'd be doing currently today that you would not be able to do if you're forced to limit your review?
It simply addresses the range of alternatives that would be considered in the practical alternatives analysis. So generally, we would look at alternatives that are off-site, away from the project, and this would restrict those alternatives to those sites on-site within the area. So
you couldn't ask the applicant to propose alternatives that would include activities off-site?
That's what it's estimated.
And do you normally do that today?
We have restricted alternatives analysis. We have the ability to do that, and and we have on a case-by-case basis. But this really spells it out in the law, saying these are the kind of things that we would do.
I guess what I'm wondering is, can you give an example of a requirement or an alternative that you might evaluate or approve today that is off-site that would not be allowed under this provision in the law?
If there were a manufacturing activity, an expansion of a manufacturing activity that was site-specific to that site, or didn't make any sense to look at alternatives a mile or 2 miles away as an expansion because it was part of the process, we would confine it to the site.
Okay, so I understand it, if, for example, a company like, say, Ashley Furniture wanted to expand into a wetland, under current law, you might have the ability to ask them to prepare an alternative that had that expansion located in somewhere else that wasn't a wetland.
I think we would look at that as part of the, we have looked at that depending whether or not it's part of the process in restricting our alternatives.
Okay, but today you would simply, what this would require you to do, just want to be sure I'm clear about it, would be to simply evaluate a yes or no on that development in that wetland and not require the applicant to consider an alternative that might involve doing the same thing outside of a wetland.
No, it still requires minimization and it still requires avoidance, but it would restrict the alternatives to the site or to the area rather than looking for off-site or other alternatives that might be a mile or 2 miles away. It would restrict it to looking at alternatives to on-site. And Lisa, maybe you can comment on that.
Yeah, I think we explained it quick. It says, starting on line 18 of page 27, limited to review to those practical alternatives that are located at the site of the discharge or located adjacent to the site. So, not requiring, in that example of a manufacturing facility, so rather than asking them to completely relocate somewhere else, the bill would provide that we would narrow that scope.
And on that line 20, the requirement that it appears to create a requirement that you determine whether there would be a demonstrable economic benefit. And I'm guessing that there aren't many people who would be proposing a discharge into a wetland if there wasn't some kind of an economic benefit for somebody. I guess I have a question for you and for the author about that. How would the department, Mr. Johnson, how do you anticipate making that determination?
I think it probably what we would look at is whether or not there's an economic impact to the society, to the individual that is proposed. But there are many projects that I would argue that are for the convenience of the individual, like, for example, construction of a garage adjacent to a house for parking or whatever, expansion of a soccer field that is for the convenience of the community. They're not necessarily demonstrable economic impact, but for convenience. I think we'd have to make some determinations that's related to economic impact, and I don't have the guidance on how we would do that, but clearly, there are activities that fall in and out.
Okay. I mean, Representative Mershaw, is that a provision that, do you think the way that's worded right now is enough to assure that there's a real public benefit here that would be created by this project versus the potential for some out-of-state individual to, basically be enriched at the cost of public benefit?
I guess I think that it's up to the department to make that determination.
Yeah.
And I think that as they work with things and they see every situation that comes up, I think they're qualified to make that determination based on the bill.
Okay. I would hope that there would be an opportunity to look at that more closely, personally. I hope you'd be open to sitting down with us to review that. Final question, if I could, Mr. Chairman. Representative Dano brought up the question about his NARIs, and I'd like you to clarify this if you could. And, over in Jeff 2, you have an entire shop devoted to cataloging natural heritage, endangered species occurrences and high-quality wetlands and natural communities and streams and rivers. And does this bill retain the department's ability to weigh the existence of high-quality wetlands and make a decision that's in part based on the quality of that wetland, whether it's rare species that might be there, or its size, or its chemistry, and its, you know, engineering functions. Because I don't see anything in the bill that directs you to give additional weight to a high-quality wetland.
Well, if you look at the general permit section, it does does specify certain wetlands that would enable the department to kick out to an individual permit process, and then it would be the standard permit process that we've used all along for avoidance, minimization, and no significant impact. So if you look at the general permit, I think there's 7 or 8 categories that would say these are quality wetlands. Essentially, what we're saying, these are wetlands that would allow that general permits may not be applicable, and would allow the department to say, no, we're going to do an individual permit process.
But that wouldn't be a statute. You would just that you still had the authority to do it.
Well, it is in statute. It is in this proposal. Page 20, lines 3 through 9.
Mm-hmm. Yeah, my only brief observation on that is that, well, it's a good list. I expect that we might hear a testimony today indicating that there could be a wide range of high-quality occurrences of wetlands that may not fall into those categories.
And I would comment that if there is additional wetland types that you feel are appropriate to include, I think those would be good recommendations for us. These are recommendations that the staff came forward with and after request of the representative himself.